you'll have an attorney. Okay. As to the Ms. Cohn, anything to know about the treatment component on that other case, or?
Yes, Your Honor. Mr. Todd indicates to me that he did do a domestic violence assessment about a month or so ago, and it has been engaging in treatment through methadone clinic he uses. I don't have proof of that to show the court, but if Mr. Todd were to remain in custody, I think it'd be very unlikely that we'd be able to get the court proof of that.
So let me turn to the state on this probable cause finding. What's the state asking on these matters?
Your Honor, the state has on the one that's on for prelim DVPC, the state has no objection to PR with no criminal law violations and no firearms or dangerous weapons. I would note that the victim advocate was on earlier but had to log off for a meeting, but she left me with a message to convey to the court. She said that the victim in this matter does not want the order. The defendant has been doing very well in counseling and there have been no issues, and that the victim believed the order had been rescinded. I understand that the victim advocate attempted to reach out to the victim. It sounds like an email bounced back, so I'm not sure that she's present over Zoom, but that is the message.
All right, so you're asking for release on both these matters, and said Ms. Moreno would need to bring that up to the court, or the attorneys could do that request, but right now the order is still in effect. So unless the state's asking the court to lift it at this stage.
No, Your Honor.
Okay. All right, so Ms. Capone, anything as to release conditions or release?
Your Honor, we would just ask the court to release Mr. Todd on his own recognizance and no objection to those conditions on the new cause number. As I previously stated, it's rather difficult for someone to get proof of treatment to the court when someone's in custody. So I think it'd be beneficial for Mr. Todd to be out to get proof of the treatment classes that he's been doing. And I will also note that Mr. Todd has received food stamps and he does financially support an 8-year-old child. Those are things that not only make it motivation for him to remain law-abiding, but also make it good reason for him to need to be out of custody and unable to post bail if the court was inclined to ask for impose it. I'd also point out that even though there is a rather long warrant history, he has no active warrants. All but one are 2019 and older. So I do believe that at this time it's appropriate to release Mr. Todd, especially given that I've given the court updated contact information to ensure that he'll get notice of future court dates.
So, Mr. Todd, that no contact order is in effect. You know, the allegation and what you pled guilty to is giving Ms. Moreno a black eye by punching her in the face. And so you pled guilty to that. We issued a no contact order. You're not in treatment, and that no contact order unlikely, it's not going to be lifted, unlikely to be lifted unless you are showing compliance with the court order to get treatment so that you're not causing harm to your family members in the future. So you know that. You know it wasn't lifted. Don't violate it. This is what happens. You end up in custody. So even at the request of Ms. Moreno, even if she invites you to violate that order, you end up in custody, potentially charged with new crimes. That's where we are right now. So
hey, baby, you want to violate an order?
We're going to release you here. I'm going to set a probation violation hearing, and I'm going to set a let's set this in a couple of weeks. Same time, just in case. I think we'll set it on the probation calendar as well as keeping the other one backed up to it for now on the. Oh, okay, perfect. So 18th. 18th. Okay. What time should I?
I don't know. Nisqually looks promising.
Yes.
We may get lucky here.
All right.
I love
So we'll be
getting lucky.
back September 18th, 9 o'clock. You have to be back.
Okay.
And you got an attorney to represent you. And we're going to take up this failure to comply, as well as potentially an arraignment on the allegations.
Okay.
All right. So in the meantime, you don't violate the law, don't violate this order, don't possess firearms. And all the better as soon as you can show proof to district court that you're in treatment. So talk to your treatment. If you're doing domestic violence treatment, then talk to them and say, hey, district court needs to know. How do we make that happen?
All right.
We're not getting any information that you're doing it, but I'll give you this chance to get it done out. All right, so you're back September 18th at 9 in the morning.
All right. Thank you, Your Honor.
Thank you.
All right, I just gotta ask the ladies: is this hair color intentional, or is this like a grow out from a prior color hair? These are guy questions. She just was blonde and then let it grow out.
All right, back to you, Ms. Capone.
Your Honor, with me is Ms. Bennett, number 6 on the calendar.
See, I get every response.
Here for an arraignment on an allegation of driving under the influence and giving a false statement. So
Thank you
Ms.
for
Bennett, so
maintaining
you're
my
Lynn Ann
confusion.
Renee
Chat.
Bennett.
Appreciate that.
Yes.
And what's your date of birth?
1982.
I'm right where I started before
And
you
Ms.
guys weighed in.
Capone.
Thank you, Your Honor. I spoke to Ms. Bennett earlier, advisor of her rights. I believe she understands them. We're not contesting probable cause for today's purposes, asking the court to enter a plea of not guilty and to appoint counsel for my office going forward.
All right, so Ms. Bennett, I will appoint Thurston County Public Defense to represent you after today as well. That's Ms. Capone's office. And I will enter a plea of not guilty to the both of those allegations. And then I'm going to hear from the attorneys here about possible restrictions on your behavior and make a decision about release conditions. So first off, I'll hear from the prosecutor, Ms. Kitmacher.
Yes, Your Honor. The defendant has a prior DUI from 2016 for which she was convicted. And there is an active warrant as well as a conviction for false statement to public servant, from the same incident date in 2016 for which there's an active warrant. Warrants were issued in 2021. Defendant, I counted 23 warrants in the last 10 years, including the active ones. The state has concerns about the defendant's likelihood of appearing at future hearings, public safety concerns based on the defendant's history of DUI. In this case, the defendant indicated to law enforcement that she gave a false name because she had a warrant showing that she was trying to escape the administration of justice. State is requesting bail in the amount of $5,000 in addition to heightened DUI conditions of no new law violations, no drugs or alcohol, no bars or taverns, no driving without a valid license and insurance, no refusal of BAC, ignition interlock device, scram, and pretrial services supervision.
Is this alleged, what's the substance that's alleged here, intoxication?
This is an alcohol, Your Honor, and there's a BAC.
Okay, and are you aware of what Lewis County's allegation was? Was that, do you know?
I'm not. I can pull it up on Jabs and see if I'm able to.
It's okay. All right, so let me turn to Ms. Capone.
I also have two
Thank you,
sisters.
Your Honor. We'd ask that Ms. Bennett be released on her own
Addition to 4
recognizance.
flamingos.
No objection to
What I've
About
learned from
heightened
that,
DUI conditions, Ms. Bennett indicates to me that she would not be able to
stay out of
afford
their
any
way.
amount of bail if the court was inclined to impose some. She is working and has had new law violations since 2018. She's been doing her best to try to take care of some things. We did discuss the warrant out of Lewis County. She indicated that she was supposed to do a sentence on EHM that she did complete, but the court did not get the proper documentation on that, and she's working on trying to get the court that documentation. I have provided the court with a good mailing address for Ms. Bennett. She doesn't know her new phone number off the top of her head, but she can get that to the court if she is to be released. I would note that there was a relatively low BAC alleged this case. On the low end, it was a 0.089. So given these facts, the fact that she's had no new law violations since 2018, that she's working and it needs to be out to maintain her employment, and that serves as a reason for her to remain law abiding. We ask the court to release her on her recognizance, no objection to those enhanced DUI conditions.
I'm gonna look into the Lewis County District Court docket just to see what I can determine from that. Goes way back. It's an old
I
case.
mean, who
from
knows? Probably.
2016, is it? 2015? 2016. And yeah, warrant was issued in 2021. Given an extension of time to do the jail commitment. And then a declaration of failure to report to jail received from the Lewis County Jail in August of 2021 non-compliance report, and then thereafter a warrant was issued and
Yeah, shout out to
been in
Lakificent
effect
Slayer.
for
She
2
sent me a
years
good.
now,
She sent
so-
me the SovCit clip. It's good. It's still baking,
Ms.
but
Bennett,
we'll get there in a minute.
I'm gonna have you post bond, and the reason being is you're not a good risk to release on your promise to return. You don't comply with court orders is clear from what's going on in Lewis County. And the warrant issued
She's
there.
not a good risk.
I'm gonna have you
We'll just
post
leave it there.
5,000 cash or bond bail to be released. You post that, then I'm gonna put you on pretrial services supervision to make sure you get back to court, make sure you follow my orders to stay clean and sober and law abiding.
She's
In
wrecked some men's
addition,
lives.
I'm
I
gonna have
guarantee
you have a scram device now, second DUI, just outside of 7 years, but I see that you pose a danger to the community. So you're gonna have a scram device within 48 hours of release. That'll be paid for by the county, so there's no impediment there. And you'll submit to pretrial services, sobriety monitoring, whatever they believe they need to do. I'll set a court date, yeah, most of caution here in just a couple weeks, the 20th on the 10 o'clock calendar, Friday, the 20th on the 10 o'clock calendar. If you're still in custody, we'll see you in custody. My hope is that you'll post bond and we'll have you there and you and your attorney can be there to discuss the matters, but you'll have Thurston County Public Defense to represent you. You stay clean and sober, no alcohol, no marijuana, no non-prescribed drugs, no bars or taverns. You don't drive unless you have a good license, proof of insurance, and the ignition or lock device. And you report to
Hey, Debbie
pretrial
Downer.
services as soon as you're within 48 hours of release. And you have that scram device on your body within 48 hours of release. And that's it for today. Nisqually, your name?
Savannah.
Sorry?
Savannah.
What's your last name? Still didn't catch that last name. Taylor.
Yeah,
Okay, gotcha now.
sorry.
All right, Ms. Langley,
Huh?
wondering if Ms. Langley is with us. There you are. Ms. Langley, have you had a chance to talk with Ms. Taylor?
Yes, I did.
Okay. All right, so now that we can hear each other. So you're Savannah Grace Taylor?
Mhm.
Yes, no?
Yeah,
Okay, and what's your date of birth?
6/4/1998.
Okay, and I've got a mailing address in Lacey, 5700 Turf Lane Southeast.
Yeah.
Need answers. Okay, that's a yes. All right. So Ms.
She has an
Langley?
odd affect.
Thank you, Your Honor. We did have an opportunity to talk about the charge and about her rights. I think she understands them. At this time, I'll stipulate probable cause for the purposes of this hearing only. Enter a plea of not guilty to each count.
All right. Well, Ms. Taylor, you're charged with allegations of resisting arrest and theft, and I'll be entering pleas of not guilty to those both. And we'll appoint an attorney to represent you from Pacific Point Defense. One of the attorneys from that law firm will represent you, and the Squally there can give you information on how to be in touch with Pacific Point Defense. So just remember to ask. And we're going to set another court date. I'll be ordering you back to court, but I'm going to talk to the lawyers here, the prosecutor and Ms. Langley for today on your behalf about release conditions or possible restrictions on your behavior until you resolve the matter. So first off, I'll hear from the city prosecutor, Mr. McClellan.
Thank you, Your Honor. No really other in-state history for Ms. Taylor. No objection to her being released on her personal recognizance with conditions of not committed law violation. As for no contact with the Lacey Liquor and Beverage, it's on Whitman Lane. And, you know, I
Lacey
can't
Liquor and Beverage
say how Ms. Taylor's doing today, but I do feel
is the start of
appropriate to ask
a
the
lot of
court
these
to
cases.
consider requiring a DCR prior to release just based on the information in the report. The officers, part of that resisting involved some pretty erratic behavior to the extent where during transport, she was banging her head on the partition multiple times, bleeding. They had to take her to the hospital. They had to stop several times to put on a different helmet on her head and foam padding in the partition just to protect her. And some yelling and screaming. And so obviously I don't see that behavior being exhibited now, but it's still recent enough where I feel appropriate to have the court just make sure that she's, if there's other concerns that need to be addressed prior to being released, if that be looked at. So that's the basis of the request and asking the court to consider that.
And so law enforcement there didn't think maybe it was intoxication or not, or what?
No, I think it likely could have been. There was noted when she was searched, and they searched her person since her arrest, there was a crystalline rock substance inside a zip-up purse that appeared to be methamphetamine. Again, I don't think that was that I saw was tested. So it's very likely it was under the influence of something. So that could be the contributing factor to that behavior, but without knowing for sure.
Yeah, without getting into further detail, there were drugs involved.
Okay. Ms. Langley?
Thank you, Your Honor. When I spoke to her today, I think she seemed tired, but I didn't have any particular concerns. So I'll defer to the court.
Okay. So, Ms. Taylor, bad night, but now here we go. You're being prosecuted, so you have to come back to court. I'm going to release you. And let's see, we've got a mailing address that I confirmed. Would a text message reminder help to get you to court?
Yeah.
Okay. You ready? You got a phone number that we should use?
360.
Okay, I'm not going to dox her. And the hearing's basically over. I wanted to see what happened there. My stream is baked up now. We're going to go to that. But I cut it just in time. I don't want her phone number on Law Talk with Mike. I just don't. That's the way I am. All right. Let me see if I can find my video now. All right. So I did this and I forgot to. Yeah, I have to render the video before I start. I started the stream and then I saw that and it has a long render on it because I got a lot of clips. That's why we are where we are. Let's all right. Let's go. Party on.
If he's not in there, I can call him later.
Thank you, Your Honor.
Okay, is to
No,
Keisha
should I have?
Culberson there?
How you doing? Long time no see. I apologize,
see me.
but I really got to see.
No, ma'am, no, ma'am, no, ma'am. No, long time no see. Let's see here. I got a
What you
couple
mean?
files for you here. 23-02087 and then 21-00529. Council appearance.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Culberson for today's arraignments.
Okay, that was collection. Okay, ma'am, are you okay?
I'm fine now.
Okay, are you under the influence of anything?
No, I haven't been. No, I actually am sober. I turned myself in.
You turned yourself in on this, ma'am?
Yes, ma'am. I can't even see you. Where are you? Okay. Yes, ma'am. I get sworn.
Okay, very good. Okay, I'm gonna do, let's see, what is this? I got two files. One's a probation issue. The other one is a collections matter.
Oh, I can pay that. I'll pay that. What's today? I can pay that.
Ms. Culberson, give her a second. She's just telling you information right now.
Yes, ma'am.
Okay, I have a requested summons for probation violation. The allegations, Ms. Culberson, are that you violated the terms of your probation before me by failing to submit to testing and that you never enrolled. It also says that you failed to enroll in intensive outpatient treatment and you never provided proof otherwise to probation. It says that you failed to enroll in CBT, nor did you provide proof of that to probation, and that you failed to engage in mental health treatment, nor did you provide proof of otherwise to the probation department. It also states that the defendant has failed to report to the appointment orders back on May 20th, 2024, and then failed to report to the rescheduled appointment back on June 17th, 2024. Defendant had absconded from probation. And so contested hearing on these violations. You have the right to be represented by an attorney at that hearing. If you can't afford to hire an attorney, you can request the public defender be appointed to represent you, okay?
Yes, Your Honor.
Okay. Are you requesting an attorney for this violation?
Yes, I am.
I'm going to enter a plea of not guilty on your behalf. Note that you are requesting a public defender. We'll set this for a hearing on the probation violations, okay?
Yes, ma'am.
Stick with it.
Thank you.
It gets good.
Oh, September 10th.
Oh.
I will wear it.
Looks like it's already set, September 10th at 1:30.
Okay, I got the paper. Yes, ma'am.
Okay, you'll be remanded until that time, okay?
What, I can't get a PR bond? I will show up at court.
You absolutely can't get a PR bond. You've been in bond status on this, ma'am, since April after absconding from probation. I saw you in April. I told you that you needed to report to probation by Monday, 9 a.m. Otherwise, bench warrant would issue. That's exactly what I said and exactly the note that I wrote down on April 26th. You didn't report the allegations so that they reset it for you as a courtesy, and then you didn't report again in June. And then the allegations are that we haven't seen you, nor have you done any of the things that you were supposed to do. Excuse me?
I was locked up north.
Okay.
I had a case. I did go up there, but it was a 2-week wait. So since I had a 2-week wait, I didn't want to catch no cases or could violate. I was trying not to violate probation up here. So I went up there to check on my case. They needed me to go in. And they called y'all and told them, and I have the paperwork, that I was up there and I just got out on the 30th. and I bought my own bus ticket, and I just got here.
And Your Honor, if I may, briefly.
Yes.
She does appear to have been in the custody of Kent County, specifically the 61st District Court for some time. She was just released on the 28th last week. I cannot find their court record system is down right now, so I can't find the exact date they went in custody, but it appears it was a file that began in late May, and she seems to have gone into their custody sometime in early June and has remained there since that time.
I can believe that because she was supposed to report for our probation though back in April and she didn't do it. So that she went to custody in June, 2 months later, she was already late for reporting for hours. She was already in warrant status here.
And I did too sign up. It was a 2 to 3 week wait because she said that it was going to be a while. So,
okay. Got it. Everybody else that went to sign up for all this, the treatment that I ordered similar to yours was able to get it done though. So.
But if it was a wait and then I went up there and then she just said that, that's exactly what happened. And I don't do stuff like that. You would have caught me in the city. You've never seen me do nothing like that.
Okay, sounds good. Well, you were supposed to take care of this in April and then they put it out until May and then till June. And the records we have that you were now in custody in the 64th district from June until now. But by June, you were already in warrant status here.
Is it possible that I can get one chance and that's all for my life? Because I'm tired of getting locked up. She just said I just got out of jail. I mean, seriously. All I know is
the only possibility that you have is to see me on the 10th for your court date on here, and we can talk about what we're going to do with the underlying case at that time, because the recommendation from probation is to terminate your probation and sentence you to jail time. But I'm not going to go back and forth with trying to locate you for that. And I also want to put on the record that this is not the first allegation or bench warrant that you've had, because I had to go back and forth with you appearing in court in the underlying case as well, okay?
Well, I'm done. I'm done with everything now.
I'm done too. So we're on the same page. I'm done too. Next. We're going to reset the collection until after we address the probation.
Ms. Culberson, go with the officer.
Excuse me?
I said bitch.
93 days contempt. Watch your mouth. See you on the 10th. See you on the 10th. I suggest you get her out of here because you get some more time. I suggest you get her out of here.
Heard what I said.
Told you got worse. That was fun. That was just pure fun. I wonder why Shares ends up in jail.
All right, Officer Meloche?
Good morning.
Good morning. All right, and Miss Bay, can you hear me?
Hello?
Miss Bay, can you hear me?
Yes.
Okay. All right, I can hear you too. All right, this is 240P01688. This is the People versus Lita Bay. Officer Meloche, would you please state your name?
Yes, ma'am. First name Nathan, Nathan. Last Meloche, Mloche.
And Miss Bay, would you please state your name?
I'm the executrix of the estate for Lita Bay.
All right, so we're here today for, looks like a ticket that was issued back on July 14th of 2024. All right, Officer Meloche, it's the government's burden, so you'll go first. Raise your right hand. Do solemnly swear or affirm the testimony you're about to give is the truth and nothing but the truth under the penalties of perjury?
I do.
All right, so what can you tell me about the ticket that was issued on July 14th, 2024 Toledo Bay at Coolidge and Pearson in the city of Oak Park.
Yes, ma'am. The citation was issued due to Miss Bay disobeying the red light at actually Coolidge and North End. Once we got through that intersection, Miss Bay did come to a stop at Coolidge and Pearson, and then once that light cycled through, I initiated a traffic stop just north of Pearson, just south of Albany on Coolidge there at about approximately 10:45 p.m. At that time, I went up to speak to Miss Bay. Initially, she refused. She did provide a license and eventually started speaking with me. Returned to my patrol vehicle, at which time she exited her vehicle, went to the rear of her vehicle, opened up her trunk. Went up to speak with her and escort her back to her seat in her car, at which point she started resisting. So my fellow officer and I took her to the front of my car, spoke with her, initially handcuffed for officer safety. We released her without charging her for the misdemeanor for resisting and obstructing, and we just went with the disobey red light. And actually at minute 158 of my body cam, Miss Bay does admit to the infraction of disobeying the red light, stating she had to use that.
When you say resisting, what do you mean?
So initially we went up to her, asked her to step away from the trunk. Obviously we didn't know what was in there. She then began to retreat from officers. We then grabbed her arm to help escort her to her vehicle, at which point she tensed up, pulled away, and started screaming at us.
What do you mean by screaming? What did she say?
Am I able to reference my report I have here?
You may.
Thank you. See, initially she said, that we're finger things.
You're breaking up. I can't.
Near. Oh, can you hear me now?
I can hear you. Yep.
All I have here is that she kept screaming, "Help me." Initially, when she was in her vehicle, she stated she didn't want to speak with us and that we were forcing her to say things against her will, and that she was nervous because we had our sidearms and we were near her children. Once she was resisting, all I have noted here is that she kept screaming, "Help me." And that's all I've got in terms of that. I don't have access to my body camera footage at this time.
Why is that?
This is virtual court, so I don't have access to evidence.com. I don't have a work computer, so I didn't know if it was appropriate to access mobily.
All right. And Miss Bay?
I'm the executrix for the I'm the executrix for the trust for Lita Bay.
All right, Miss Bay, raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth under the penalties of perjury?
I do.
All right. What can you tell me about the ticket that was issued to you?
Your Honor, I actually put in paperwork and asked for discovery, and I was advised that I shouldn't testify until I get my discovery packet.
So this isn't a criminal case. It's a civil infraction. You were free to order under the Freedom of Information Act any information regarding this case prior to the hearing. So it's not like a criminal case. It's a different standard. It's just a preponderance. It's not beyond a reasonable doubt.
Which is number one, wrong.
If you just FOIA'd the report or the body cam in this case. But we are having the hearing today, and you're free to give me your side of the story if you so choose.
On the day in question, I went through a red light. I had to use the bathroom, like really desperately. I had 3 teenagers in a car with me. And when the officers approached my vehicle, touching their sidearms, my daughter had the identification, and I explained to them that this was a trust situation. And they didn't care. She was terrified, and she ended up taking out my ID because she did not want us to get killed or beat up or anything, because things have happened to family members. I didn't want to get tased. She didn't want us to get tased or beaten or killed. So she ended up taking out my ID because I did not have to identify it was not a situation for identifying, but we were forced to because of the guns and stuff, and my children were terrified. My son's girlfriend was in the car. He was terrified. I told him it was a trust situation, and I told him I had to use the restroom. And because
do this today, Your Honor, my health is in jeopardy right now.
what's that?
I have IBS, irritable bowel syndrome,
Mm-hmm.
and what's been going on is
Very stressful.
I'm bleeding inside, ma'am.
Going through the red light, which there was no traffic. The traffic light is to direct traffic. There was no traffic. I really had to go, and I was really trying to get to the destination because I have a medical condition that's life-threatening right now. So I explained it was a trust, and they went to the car, and I got out to get tissue out my car, which I have a receipt and a picture that I did have tissue in my car. I was going to use the bathroom on the side of a house or wherever because I was not going to expose myself to waste matter with my blood condition. Forced me, they all grabbed me. Then all of a sudden somebody had their hands between my legs, brisket touching me, my breasts, searching me. They pushed me up against the car. They put cuffs on me in front of my children. They put me in the back of the car. I was screaming for help. They went up to the car and they were taunting my son in front of his girlfriend and his little sister who looks up to him. Like, I said, I just had to use the bathroom. I asked them nicely. I said, can you please just sit me on the ground? I do not want to waste inside of your car. I wasted myself in my car once I got back in my car after they put me in the back of the car. So that's what happened on that day. And I asked the officers.
I wasted myself. I didn't catch it the first time. That's fun.
How would you want your mother handled? I'm an older woman. And he did this in front of my children. I went to the temple earlier that day, in the Hindu temple, and did sacred rituals. Wasn't nobody supposed to be touching me. And somebody just came up to me and was touching between my legs and my breast. And I don't know where they came from, and they were all surrounding me.
Anything else you want to say, Ms. Bay?
I was screaming for help because I was terrified for my life. I was not guilty of anything, but needing to use the bathroom and not wanting to soil myself. I just wanted to get to my destination, which was off of Oneida and 9 Mile, which literally.
Are you done with your false allegations yet?
2 minutes away. I did not make it.
All right, the court has heard the testimony from Officer Milosh and from Ms. Bay in this case. The standard is a preponderance of evidence. Mr. Milosh testified that he saw Ms. Bay run the red light at Coolidge and North End. Ms. Bay acknowledged running the red light in question in this case. The people's burden is satisfied beyond a preponderance of the evidence in this case. I'm finding Ms. Bay responsible for running a red light. The fine is going to be $165. You'll have till October 1st to pay it. I will send that to the Novara address where we sent the other notices, so you'll get the paperwork in the mail. You're all set.
Excuse me, Your Honor. So what I'm asking you is, I have a question. You're telling me, is the court telling me that trust situations are not seen as trust because this is a trust matter? This is not
Right,
what
so
you
Ms.
think
Bay,
it is.
there's no trust situation recognized by the court. You are responsible. Make sure you pay the fine by October 1st.
Which is number one, wrong.
No, sure.
All right, Officer Walsh, you're all set. Have a great day.
Very much.
Thank you, Lucas. That was.
All right, I'm assuming that's you,
that was
Mr.
pure fun.
Butler, right?
Yes, it is.
All right. This is a citation that was issued on July 20 of this year on Swan Avenue there in the city of Allegan. So it's a city ordinance against burning trash. Mr. Butler, you're here on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you're here to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I was going to contest it because, yeah.
All right. Then the first thing I'll do is swear you both in. You want to go ahead and raise your.
I was gonna contest it because I wait. Now I gotta find it. Where is it? Oh, here we go.
Challenging it
Okay, in what way?
in a good way.
It reminds me of that. It's the guy version of that.
Right hands. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes, Your
All right. Mr. Butler, it makes a lot more sense for me to start with the officer. He has the burden to establish to me why you were issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf. All right?
Okay.
With that, officer, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
Yep. I'm Officer Dykema. I've been working for the Allegan City Police Department for roughly 2.5 years now. On the date of 7/20 of 2024, at approximately 22:42 hours, the Allegan Fire Department was contacted for a smoke investigation by the Admiral gas station. They were able to locate a fire at 210 Swan, where they made contact with Mr. Butler, who admitted to starting the fire. While the fire department was extinguishing the fire, they found parts of a couch within the ashes of the fire. That was when they contacted me for my assistance. When I responded out there, I made contact with the chief of Allegan Fire, who informed me that he wished for me to issue a citation for documentation purposes due to them having to respond out there multiple times in regards to fires. There I was able to speak with Mr. Butler, who admitted to starting and maintaining the fire. He stated that he was burning a couch, but before burning the couch that he had separated the wood and other components apart from like the cushions and fabric, so that way it was safe to burn. The chief of Allegan Fire, Chief Brink, was able to explain to Mr. Butler that that still falls underneath the city ordinance due to some of the materials not being safe to burn, and that the only materials that are allowed to be burned within the city are actual wood, like campfire wood. It was at that time that I issued Mr. Butler a citation, citation number AP 42494, for violation of City Ordinance 12.32.
All right, Mr. Butler, what is it you'd like to tell me?
I just feel like if I broke that couch all the way back down to wood, that's still me just burning wood.
No, sir. That's not wood, sir. That has varnish and stains. That's a commercial product. What they mean is you can burn wood like
that you guys have
trees and sticks and things that are natural wood, not manufactured furniture wood, sir.
What's the difference?
So you understand?
Like, I understand it's treated, but so is the burn pits that you guys have with burn out of. Those are treated with chemicals too.
Mr. Butler,
so
that is neither here nor there. You are here on this citation because what you're burning is something you're not allowed to burn. You're putting all kind of weird chemicals and stuff in the air, man. I would find you responsible on this for the citation. It's right.
I'm going to appeal this anyway, so it don't matter.
All right. Then you're all set. Thank you.
Thank you.
I just liked you're putting weird stuff in the air, man. And also Judge Norbeck's complete not caring about him appealing it. He's like, yeah, okay. Yeah, you appeal it. Good luck with that.
All right. So, Mr. Hernandez.
Oh, this guy.
All right.
This guy is taking the naughty adventures too far. He just really has.
This is in the matter of the people of the state of Michigan versus Pedro Hernandez, file number 2023-21325FH. Ms. Underwood, we had a prior probation violation which alleged that he was arrested on February 10th of 2024 for domestic violence in violation of a PPO. He was also arrested for MDOP 200 to 1,000 from an incident that occurred on January 10 of 2024. On that one, you appeared and you were appointed to represent Mr. Hernandez. We have a new request and summons for probation violation. Mr. Hernandez admitted to drinking and refused to test during arrest by the Adrian Police Department on August 3rd of 24. He allegedly crashed his vehicle and fled the scene on foot. An open bottle of tequila was also found in the vehicle. This is in violation of term 14, 15, and 16. Ms. Underwood, I'm not sure if you can verify whether or not he has charges in district court regarding that. I would be surprised if you didn't. Just put your hand down, Mr. Hernandez. Just put your hand down and be quiet right now.
Your Honor, I can speak to that. He does have pending charges. I can look and see what that next date is if you just give me 1 second.
You'll see going forward, Judge Anzalone, who's a sweetheart, absolute sweetheart, has had prior dealings with this guy, and she has zero patience. She is done with him. It's fun.
I'm confused.
I know he is a violation scheduled. It says September 18, sentencing in district court on September 9.
I'm going to show up.
And August 24, he got new charges on an OWI 3rd, according to the probation violation report from Mr. McCarron.
He does, and then that case is, let's see, we charged it. I don't see the next date though.
Can I speak with my attorney?
Not yet. You just sit there and be quiet for a minute, Mr. Hernandez.
There we go.
How about, and stay with me now, you shut your hole.
Looks like he is set to be arraigned tomorrow at 1 o'clock on those new charges.
All right, and he's on mine on a 93-day misdemeanor right now. So, Mr. Hernandez, you understand we have a show cause, probably not the most recent one because you've had charges after that for violation of probation by admitting to drinking and refusing to test during an arrest by the Adrian Police Department on August 3rd of 24, crashing your vehicle, fleeing the scene on foot, and then an open bottle of tequila. You understand those are the pending charges against you on this violation of probation? All right.
Yeah.
Do you want...
Would you
hold on and listen to me? And Mr. Hernandez, it's about time you get control of yourself because I've got zero tolerance for you right now because you are in a whole lot of trouble and you like to talk over everybody and not focus. That's your problem, plus you're an alcoholic. But do you understand you've got this pending violation of probation against you?
I really enjoyed plus you're an alcoholic. She just throws that in there. It's true. It's the whole problem, of course. It's usually not said out loud.
No, I don't understand. I thought I already had a court date set.
So, yes or no? Yes.
I think I can enlighten the confusion here. There was also a felony case he had to VOP on that you arraigned him on August 5th, set for hearing August 14th. Or I'm sorry, set for hearing September 18th.
So he's got a new felony case I've got as well?
No, it's a probation violation in circuit court.
On a felony case?
Yes.
Okay. So, Ms. Underwood, we also have a probation violation on his felony file set for September 18th.
Your Honor, he is going to be arraigned on new charges tomorrow. I obviously do not want Mr. Hernandez making any statement as to this violation at this point, Your Honor.
All right. So, Mr. Hernandez, you got a whole bunch of stuff going on. So the less you say on a record that could be used against you, the better. So what your attorney is saying, don't say a word because anything you say, if you because you tend to talk a lot, if you make an accidental admission, we can use that against you. Do you understand? Yes or no?
I just want to know what's going on, that's all.
Well, I just explained to you what's going on. You've got violations listen, you got a violation of probation on your felony file set for a couple weeks out. You got a new couple violations on your misdemeanor file with me because you keep catching new charges. So, Miss Underwood, do you want her to represent you on this newest show cause for probation violation, yes or no?
No.
You don't want her to represent you on this one? She represents you on the other one.
But that's what confuses me, because I thought I got VOP'd for this situation and I got pretrial on the 18th, I thought. For this situation.
This is a different file. I got you probation 2 files. I got you on probation for a felony, and I got you on probation for a misdemeanor. Today's the misdemeanor probation violation.
From what case?
This is the domestic violence 93 day.
When?
Dude,
what
you
pled
and were sentenced a long time ago. You got more, the problem is you got so many charges now, you don't even know what you're here for. But what I'm going to say is I can put you in a breakout room with Miss Underwood, but I don't want
She has had enough. I'm enjoying it so much.
you to make any admissions on the record. So my question is yes or no. Miss Underwood represents you on the other ones. On this small one, do you want her also so that she has all your files together?
Can I speak with Miss Underwood?
Do you want her appointed to you? Yes or no?
Or could you appoint me a new one?
No, Miss Underwood's the attorney you get through the PD's office. I have no say on
She sucks. Can I get a different one? No.
that. Do you want her appointed on this file? Yes or no?
Sure.
Okay. Miss Underwood, do you have time to speak with him today?
I give him credit. The one thing he does right, he complains, of course he's taking out his troubles on his attorney. The attorney's fine. So he wants a different attorney, whatever. When she says, no, you can't do that. And she said, all right, do you want her appointed? Yes or no? And then he's like, yes, as opposed to represent myself. I give him credit. He's miles above your average sovereign citizen with that decision alone.
For Your Honor.
All right. Miss Underwood's going to go through and explain. It's confusing because you have cases coming out your ears right now. So, and I will tell you, Miss Underwood, I will not be releasing him from the Lenawee County Jail right now. So I'm going to open up a breakout room and I'm going to assign Miss Underwood. And what room are you in? Jail room 2. So I'll assign you both to a breakout room and she'll try to work through it with you so that you understand. Just stop talking. Don't say anything that will hurt you.
I pled guilty to a disorderly. I need to speak with Matthew Murphy. He's my attorney that was downstairs.
Mr. Hernandez, join the breakout room. So I have somebody in the jail. Is that Mr. Wells?
Yes, ma'am.
All right, just bear with me for a minute, Mr. Wells. Mr. Murphy, we have a couple files for you. So
I'll stay and observe in case I'm needed for Mr. Hernandez.
Okay, so it looks like Miss Underwood, Mr. Murphy was appointed on the new felonies.
Oh, on Mr. Hernandez's new felony?
Yeah. So Mr. Hernandez, Mr. Murphy represents you on your new felonies. He doesn't do violations of probation. So you kind of have.
He was the one who gave me the plea deal. I pled guilty to disorderly, not no domestic.
Well, then you were sentenced, so he's not your attorney anymore on this. Once you're sentenced, he isn't your attorney anymore.
What is the domestic violence about?
I don't know. You pled to it.
I never pled guilty to a domestic.
I'm loving this hearing even more. Well, now the second time I'm watching it. I don't know you pled to it. It's right up there with, plus you're an alcoholic.
Violence, Your Honor?
Your Honor, is this, I was just looking at the ROA. This was, I think this was a file from before, like he had a private attorney, and this is a violation of probation. So there's confusion there, I think. So I thought the ROA said a different.
So everybody stop talking for a minute. So file number 23-21325, let's walk through it. You were originally charged with felonious assault, which is a 4-year felony. Then let me talk. You stop talking and you let me talk.
So then you got fingerprinted. Let me go to the judgment of sentence. And you pled on October 4 of last year to no contest to the charge of domestic violence under a deferral program. You were set for sentencing December 7th of 23. I sentenced you. I placed you on probation. So you were present for all of those things. The deferral only really works if you don't violate probation, and you have violated probation a couple times. Mr. Sala represented you at one time on this file. So that's on this file is where you have the domestic violence. And I have a couple violation of probations. Mr. Murphy's not on this file anymore. Miss Underwood's on this file. So you have multiple attorneys right now because you have multiple.
Supposed to be here?
What?
Is Sala supposed to be here for his case?
When you get sentenced, they are no longer your attorney unless you go hire them again. Once you're sentenced, your attorney is not your attorney anymore. They're done with you unless you go give them some more money to represent you. So Mr. Sala is not your attorney on this file. Rhonda Underwood is with the Public Defender's Office. She's been appointed on the violation of probations. So you have Mr. Murphy on some new felony files. You got Miss Underwood on your violation of probations. Do you understand?
Okay, I want to fire Rhonda on my VOPs.
Okay, then you can represent yourself or hire an attorney.
Oh, shit. Okay.
You're going to represent yourself?
Nah, I'm going to have her represent me.
There we go.
Okay. So, so Miss Underwood, I'm presuming we need to set these over to take care of the charges because you can't make any admissions that can be held against them.
A 2-week adjournment, Your Honor, to allow what's going to happen in district court to proceed so we have more information. I've told Mr. Hernandez that we are trying desperately to protect his rights against self-incrimination by doing this.
So, Mr. Hernandez, what I'm going to tell you right now is you need to check yourself. You have a tendency to talk when you shouldn't talk.
If she starts singing "Check Yourself" before you wreck yourself, this will be the greatest stream of all time.
And not listen when you should llisten. You are looking at prison right now on all these cases. Do you understand that? Yes or no?
Yes.
Mr. Murphy and Miss Underwood are excellent attorneys. And they're going to give you advice. Whether you like that advice is irrelevant. I used to tell my clients, you might not like what I say, but I'm going to be honest with you. But you need to listen to them, you need to talk to them, and you need to be respectful. Do you understand that?
Yeah. Miss,
all right, and I will see you back on...
I'm an alcoholic. I need, help. Not...
Yeah, you'll get help one way or the other when you get sentenced.
I need a rehab or something. I don't need...
When you get sentenced, you can look at potentially rehab. But right now, you can take advantage of services at the jail. But you're not going to be released to go to a rehab program right now. Okay, you need to be very serious about this, Mr. Hernandez. You just picked up a whole lot of cases. So we'll see you back on September 25 at 8:30 in the morning, and my staff will do the notice on the violation.
Did I speak with Matt Murphy? I have not been able to speak with him.
Mr. Hernandez, I'll come back to you at the jail. He'll talk to you when he comes to the court or to the jail to see you, all right?
Judge, I'm sorry. That other one is scheduled for the 18th. Did you want that moved as well then, or?
Yeah, let's move them both to the 25th.
Okay.
All right. Mr. Hernandez, you are all set. We'll see you back on September 25.
Mr. Hernandez, I'll come tomorrow or the next day to visit you at the jail, okay?
I need to speak with you, dude.
Yeah, I know. I'll come tomorrow, okay? I was planning on doing that, all right?
All right.
All right. Thanks, Mr. Hernandez. All right.
All right. Ms. Jennings, you want to take yourself off mute so that I'd be able to hear you? That little red microphone with the slash through it, Miss Jennings. There you go. Oh, no, you turned it back on. That means I know you can hear me, but I wouldn't be able to hear you till you unmuted yourself. Little red microphone with slash through it. You need to tap that. Ms. Jennings, we will not be able to proceed if I cannot hear your responses. You have to figure out how to take yourself off mute.
Okay, you're off now.
There you go.
Okay.
All right.
Can you see that?
So this is file 2401691SC, Jennings versus Fitz. Parties are present. This is a small claims case. What
I have
that
not seen
means
this
is
yet.
we're trying to get this done without any attorneys, just having the parties here in front of me and to have this decided by me as opposed to doing something like having a jury trial. So if both parties are ready to proceed here in front of me without attorneys and me as the decider in this case, then the first thing I'm going to do is swear you both in. You can go ahead and raise your right hands. Mr. Fitz, I can't see you, but I'd ask you to raise your right hand. Ms. Jennings has raised her right hand. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
I do. Yes.
All right. So I did get a lot of information here, basically, because you guys send me the contract. Essentially, this is what I want to ask you. So, Ms. Jennings, when you signed this contract, or at least some period before July 22nd, did you get a chance to look inside the barn?
Yes.
All right. So in other words, you saw items that you considered to be of value besides the ones that Mr. Fitz wanted to keep. You signed this agreement, and by the time you go back there with people on the 22nd, those items are now missing from the barn.
Correct.
All right. So, Mr. Fitz, you see the problem here. Ms. Jennings signed a contract with you because she decided that the items that she'd be able to get per this contract were worth it to her, worth more than $2,500 in cash she paid. And that, you know, for a while she wasn't allowed in there, but by the time she's in there ready with guys to move stuff out, everything's missing. You understand what Ms. Jennings' complaint is, right?
She's saying that, the way I'm understanding, she's saying that I stole stuff after I signed that piece of paper, and I did not do that.
Mr. Fitz, I want you to listen to me instead of what you think is being said. So, she signed a contract that the contents of the house of the barn, she's going to be able to take those away except for the items that are spelled out in the contract. She pays you money to do that. And then, you know, 12 days later when she shows up, all the stuff that she saw before she signed that contract isn't there anymore.
I don't know what to say, Jan.
Well, I know what to say. You or someone you know cherry picked all that stuff out of there because it was worth money. And so Miss Jennings is standing there with nothing worth the $2,500 she paid.
What stuff was it she's talking about was high value that was in the garage that she was saying that I sold after I signed the paper? What value? They weren't no big valuable stuff in the pole barn, but small stuff in the pole barn.
Okay, this is what I want to tell you, Mr. Fitz. Did anything go out of the house or the barn between July 10th and July 22nd?
Nothing came out of the barn after I signed that paper.
Okay, I kind of don't believe you, but I'm going to have Miss Jennings explain why she's saying there was things in the barn that she saw, and then by the time she came and get them, they weren't there anymore. Miss Jennings, what are you talking about?
There was a pipe vendor back there. There were just lots of open spaces of things that were just gone. Everything, like, there was little things left in the barn. It was almost all gone.
Okay. What percentage of stuff would you say was in the barn that you saw when you signed that contract that was gone by the time you showed up?
Half the barn was gone.
Okay. And did you confront Mr. Fitz about that? What was his explanation?
Yes, we did. He said that it was his stuff and he gave it to his friends.
All right. So, Mr. Fitz, that's kind of what I'm talking about. You gave away some items to people that you know?
No, that's not true. Everything.
So you didn't say that?
Everything was still in the garage when I signed that paper. Everything was still in there. When I finally let the door open, we had a contract that they clean up the house, get everything done in the house first, then we go out to the garage. We go out to the garage. The guy tells me that I sold stuff out of the garage after I signed that paper. I told him, no, I did not. He called me a liar. I called him a liar. We had a few words.
Okay, Mr. Fitz, I'm not concerned with whether or not you sold stuff, because maybe you just gave it away. But you understand, so you're telling me there's nothing that left the barn after it signed this contract before Miss Jennings was allowed in on the 22nd?
I did not sell nothing or give nothing away after I signed that paper. Everything was still in the garage. That they saw was still in the garage.
Okay, so what is Miss Jennings saying when she said she confronted you about it and you said it's your stuff and you gave it away to your friends?
She didn't confront me at all about anything. Her worker is the one that confronted me about the stuff and told me, then threatened that the stuff that they already took out of the house that day, he's going to dump it in the yard and just say the hell with it. I said, what?
All right.
Then
so let's talk about one thing. Let's talk about a pipe bender.
$400. Did they
what
say
happened
anything?
to the pipe bender?
The pipe bender, I never had a pipe bender in there.
Okay.
That's all I can say is I did not sell nothing else after I signed that paper with her. Everything was still in the garage that was there. Maybe it's all...
I'm sorry, that was... Mr. Fitz, what is it that you think Miss Jennings saw in the barn that she thought was worth $2,500?
Good question.
What about the toolbox that was in there that I was able to keep? What about the cherry picker I was able to keep? What about the torpedo heater that I was able to keep?
Yes, sir. All of that was in the contract, and you agreed to keep that. What I'm saying is, what did Miss Jennings see that she thought was worth giving you $2,500?
Tools, welders, drill press, sandblast cabinet, a solar tank where you clean your parts up, tools to do engine overhauls. I mean, I didn't sell nothing after I signed the paper there, because what it is, I sold all the high value stuff way before I even called them in to buy the stuff from me. And now they're saying
and then
that
why was it that they weren't allowed in from July 10th to July 22nd?
The agreement was to get the house done first, then we'll go to the garage. That was the agreement. A verbal word agreement that we had that I had with Liz.
Okay, but that's not what the contract says. I'm looking at the contract.
Well, my reading ability is not that great, so I mean,
all right, Ms. Jennings, you saw him, you heard Mr. Fitz go through a list of items he thought were in the garage that were worth it.
Yes, those were gone.
Okay. So, ma'am, of the $2,500, in other words, some of this is labor that you're doing, right? Sort of cleaning out the house. And then you just expect that on top of that, you'd at least make your $2,500 worth of stuff you're allowed to take.
Yes.
And at the end of the day, did you take anything out of the house or the barn? What was the value of what was left?
We didn't take anything out of the barn at all. And the house value stuff, there was so much moldy stuff, we filled up 5 dumpsters full.
Okay, that's not my question. My question is, what did you get that was
$500 of value.
Okay. And then when you say, so that's the, you said you had expenses of $500. What are those expenses?
Yes, I paid 5 boys to help me.
Okay, labor you actually paid. All right. So essentially what I'm going to do here, ma'am, is I understand what you're asking for, and I agree with you. I don't know what happened. When you said you made a police report, was there any follow-up to that?
No, nothing.
Okay, so you haven't been contacted by them?
No.
Did you report that as what?
As, like,
I mean, to me,
money.
you're calling that breach of contract, but did you suspect that somebody got in there and took that stuff?
No, he had told me he gave it to his friends, and that's why I had reported it, because he had given it away.
All right. And when you say he told you that, you mean to one of these people you had working, not to you directly?
No, he told me.
Okay.
So
I am gonna find damages here, but I'm only gonna find damages at 2,500, ma'am. I understand where you got your 3,000, but if you were able to recover at least partial of that, that would go against that. But you are able also, you paid out of pocket $105.05 to have Mr. Fitz served and to have this file. You would get that on top too. We just call that something different. We call that cost. So you really have a judgment here, $2,605.05. That judgment will get sent out to parties in the mail. I will explain this to both of you, although I'm not sure why Miss Jennings
what about
would
the
appeal
$400
this finding.
cash he got from me that Rodney took from me, and then hollered out to Liz that I got the $400. Let's go.
Sir, I don't know what you're talking about. You didn't countersue here.
I don't know nothing about doing this countersuit or trying to sue somebody. I ain't never been in this kind of situation before.
All right. Well, so listen to me. Because you had a contested hearing, either party would have a right to say, I don't agree with what just happened there. I want you to appeal this to general civil. To appeal this to general civil in front of the district court judges, you must do that within 7 days of today's date. Your window of opportunity to appeal this further closes after that date. And secondly, you must do that in writing. It is not good enough to just request that orally. The parties understand their rights on appeal?
Yes.
That you can barely
All
read
right.
and write.
I already told him that.
Then we are all set here. I'm going to go ahead and dismiss parties. Thank you.
Well, hold on now. What do I gotta pay?
Yes,
Your
sir.
Honor?
You'll get a copy of the judgment in the mail.
How much is the judgment?
I just said that, sir. It's $2,605.05.
Returning his stuff.
Are they gonna be returning all my stuff then? That they took out of my house? That they saying there's no value? That's the reason they really bought the stuff, because that all the stuff in the house.
Sir,
That's what they're after.
Were you listening at all? She said she did recover about $500 worth of useful things. I took that off the amount of
That's
money
not
that you
true.
would owe her.
There was a lot more stuff that they took out of the house worth more than $500.
Yeah. Well, he
All right,
believed
sir.
her
We're all
more
set.
than
I'm
you.
going to go ahead and release you. Thank you.
And so do I.
So the judge.
What a mess. He did a nice job with that. He really did. It just cut to the real issues quickly.
And Ms. Logston, if you could go ahead and take yourself off mute. Ms. Rodriguez, take yourself off mute. All right. Sorry about that, ladies. I did have one going right before you guys. So we are here on this file 2401690 SC Rodriguez versus Logston. We're here as a small claims case. What I mean by a small claims case is this: we're here trying to do this without any attorneys. Parties are here today without attorneys. We're also not asking for this to be decided by a jury trial, but for this to be decided right here now in front of me. So if the parties are ready and willing to proceed without attorneys and with me as the decider of the outcome, then the first thing I would do if we're ready to proceed is swear you both in. What I mean by that is to raise your right hands. Ms. Rodriguez, I cannot see you, but I'd ask you to raise your right hand the same way that Ms. Logston is going to raise. Oh, there you go. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
I do.
Yes, sir.
All right. So I do think, as far as what I can tell looking from the affidavit and claim here, that essentially what we're talking about, I think we touched base on this. Oh, no, this is back to a motorcycle. So this is a motorcycle that parties agree, right, belongs to Miss Rodriguez. Miss Logston, you do not think the motorcycle belongs to you, correct?
No, it don't. It don't belong to
All right.
her because they went to court and my son has paid for it.
Yes,
They go
but the
tomorrow.
issue is the title of the bike is in your name, Miss Logston, and not Miss Rodriguez's.
She
Well,
wanted it in my name.
I know, I understand that.
I
Miss
asked-
Rodriguez, what is it?
I
you
asked
wish
for
to
it.
Yes, sir. So we went to court back. I got it recorded. I record everything just like this is being recorded. I recorded you last week too, telling her she admitted it. That is my bike. We went to court with Scotchless. I took it to pre-trial. It's not about the collateral stuff. I borrowed my brother money.
Okay. Ms. Rodriguez?
$5,300. Yes, sir.
Ms. Rodriguez, this is not about that lawsuit, all right? I understand what happened in that lawsuit. What this lawsuit is about, I'm trying to clarify, is this is your motorcycle, but the title is in your mother's name. All right.
Yes, for Social Security purposes. I asked her to sign off it, but she won't.
Ms.
She's saying
Rodriguez,
it's my brother.
please stop talking. All right. So it's your motorcycle, and you were able to go get the motorcycle, correct, Ms. Logston? You're not preventing her from taking the motorcycle. All right. Then there is no damages here. There's no out-of-pocket expense that I could possibly pursue in small claims. It's your bike. She's not preventing you from having or using your bike.
Okay, thank you. She sign off of it, please, and give me the title then, sir. Because she's trying to get me in trouble. But it is my bike.
Are you guys also in landlord-tenant court?
Yeah. I don't know
Ms.
why
Logston,
for, but
are
yeah.
you in landlord-tenant court where you're trying to evict Ms. Rodriguez?
Yes.
All right. Now, in landlord-tenant court, part of that eviction process is what happens to Ms. Rodriguez's possessions. If you were to bring this up in front of the district court judge in landlord-tenant court, a district court judge can make Ms. Logston do what's called specific performance, i.e. sign the title over to her. I can't make her do that. I can award you a money damages for out-of-pocket expenses, but you do not have any out-of-pocket damages here. We're all in agreement it's your motorcycle. You're able to take it, use it, ride it around. What you need is a very specific thing. You need her to sign the title back over to you. But that is specific performance. You would need to be in general civil or in landlord-tenant to have a district court judge order her to do that. I can't order her.
I just can't see a motorcycle in this situation at all. I'm having a hard time with it.
To do that. Does that make sense to both of you? Okay. So what I'm saying is there is a solution to your current problem. One solution is Ms. Logston, you could just sign it over and you would be done with these lawsuits. Or two, you could bring it up as part of your landlord-tenant case as a possession of Ms. Rodriguez's, the tenant, but Ms. Logston still has some sort of control over it, i.e. the title, and you could resolve that in front of your landlord-tenant court, or Ms. Logston, you could resolve this by signing that title over to her. But we can't proceed with it as a small claims case. It's not the appropriate venue. I just want to make sure that what I just explained makes sense to everybody, right?
Yeah, but they got to go to court tomorrow over it. The payments and
it's not over the motorcycle.
See, I can't even.
It's not over the motorcycle. It's money. It's what he owes me. It's not over a motorcycle though, Janie.
And that is between Ms. Rodriguez and her brother. That's not what she needs from you. What she needs from you is something different. All right. But I am going to go ahead and release parties. We don't need to be here for small claims on this particular matter. That doesn't mean the matter is resolved. It just means, as I'm trying to explain to you guys, there are other more appropriate avenues for you guys to resolve this, right?
Yeah, there is.
All right. And I'm going to go ahead and release you. Thank you.
Thank you, sir.
I'm going to release us. And she said, thank you, sir. I'm not signing that title for her.
Okay, I'll see you tomorrow.
It'll never end.
Mr. Galvin?
Right to the end.
Good morning, Mr. Galvin.
I'm not signing that
Do
title.
you think you understand your rights? Do you have any questions?
No, ma'am.
The charge before the court is called walking on the highway with traffic where there was no sidewalk. That fine range is $100 to $200. Do you want to plead not guilty because you want to hire an attorney or have a trial?
I'll plead guilty so I can get rid of it.
Okay, on your guilty plea, finding court costs is $120. Now your time served. When I read what happened yesterday,
yes, ma'am.
I'm very concerned. Do you have somebody that's helping you?
No, ma'am, I'm homeless.
Well, homeless people have people to help them. We have our families. We have services from Tyler Resource Center. We have services from Salvation Army. We have a lot of services in Amarillo to help people that are homeless. We give there's clothing. What was happening yesterday?
I was sleeping in an abandoned basement. It was around lunchtime at Powder District, and the kids were throwing their trash where I was sleeping at through the chimney. So I got dressed and was gonna go to a friend's house that usually goes and lets me around lunchtime. Well, as I was walking, Powder was at lunch, and you know how kids are when they get together and go and they leave campus for lunch. They go and smoke their cigarettes. They go and do their thing. Well, I was walking by, they were still throwing trash at me. And since I had an accident last week, my arm was kind of broke. I feel like it's broken, but it's real swollen. I only have one hand and one arm to use. So I was carrying the ball belt with me because, of course, I'm homeless. You know, walk around at night, you never know what you're going to run into. Any type of protection will help you. Well,
But you need to stay away from the schools. The schools can't afford, with the worries that they have about people, to have you sleeping around their dumpster.
But see, it's not, I wasn't sleeping in a dumpster, I was sleeping inside my grandfather owns the property. There's just no house on it no more. So I was sleeping inside the basement, which goes into the ground, you know what I mean? All right, well, as I was walking, some teacher was on a golf cart going around, you know what I mean, all the block checking. And I told him, I said, man, you ain't supposed to be off the campus if you're on the clock. But like, these kids are leaving campus because it was a privilege. I went to Powder myself, you know what I mean? And I said, you know, some of these kids do need a little bit of correction. You know what I mean? When I was growing up, if I did anything wrong to anybody, my mom and dad would whoop my ass. You know what I mean? Responsibility, respect to older people, even though you don't know them. Well, next thing you know, there was a witness with me. I had somebody with me, walking with me, but he was on a bike and walking stop. We're about 4 blocks away from Powder High School.
He seems pretty rational for a guy in a yellow dress, to be honest. It's kind of interesting. I have to thank Katie. It looks like Katie's snappy for this one. Thank you.
Going towards the boulevard. And that's when Officer Matthews and Espinosa pulls up. And instead of not even asking any questions, he says, hey, you know, and being an American citizen, you know, I mean, you could pretty much approach an American citizen with respect, even though if you wear a badge or not. Well, he got mad because we didn't address the way he wanted us to, so he pulled up. That's when he started. If you see the video, by any chance you happen to get time, you know what I mean, you remember the conversation with me, you see the video that he had on his cam chest, you will see where the disagreements, the hostility, the disrespect, the abuse.
You're welcome to plead not guilty and come see me on a bond, and we'll have a trial about the whole thing. But I'm concerned about, you know, incidences around the schools, and that's what they're worried about.
Yeah, but most of the time they create them incidents.
Well,
I've been
things are happening on school that shouldn't happen. So,
right, ma'am. I've been staying in that basement for almost a year now. Almost a year since my grandfather bought it. I've never had no notification.
okay. All right. Well, your time served. You don't have to come and see me unless you decide you want a trial.
Yes, ma'am. Thank you.
Okay. You can return to your pod. Jeremiah Lankeet.
Yes, ma'am.
How do you say your last name?
It's Lankite.
Lankite. I think I've asked you that before.
Yes,
so you
ma'am.
had no contest back in January on operating a vehicle in expired plate and speeding 63 in a 45. Total due on those two was $635. You set a payment plan, and it looks like you only paid one payment. When we set that for a show cause, you failed to appear. Why didn't you either pay or come back to see me to change that payment plan?
Yes, ma'am. I didn't come back because I had wrecked my vehicle and I needed to get more funds to start getting a vehicle and get back on my feet. I no longer had the money to pay towards my tickets or even way to go up there. My job is down the street from me. It's 3 minutes away, so I was walking and just doing what I the best that I can to try to get back on my feet. And
Well, I'm gonna Google how far where you live is from my court, because I don't think it's very far.
well,
So
that's
you are less than a mile away from my court. It's 3 minutes by driving, and by walking, it would take you 24 minutes to get here. You
Now-
should come to see me.
Ma'am, my actual, that's where all of my mail goes to. My actual address is 1550 South Bell Street, apartment 342.
Why don't you give us that as your mailing address instead of this 14th Street one?
Yes, ma'am. It's because the mail at that at Axiom at Bell, the apartment complex, I never received my mail ever. I've tried to get packages in, multiple things, all this stuff. The management there is just very bad, so that's why I have my mom's address as my mailing address.
So how do you get your mail from her?
I have a vehicle now.
But back in the beginning of this year, you didn't?
No, ma'am. I wrecked it on the highway.
Okay. So you owe $635. I'm giving you $300 jail credit. You owe $335. Is somebody gonna be able to come to the jail to pay that?
Yes, ma'am, but they should be already in the process of paying it. They just wanted to see what was going to happen first.
Do you get food stamps or federal housing?
No, ma'am.
Do you support anybody other than yourselves?
Yes, ma'am. I'm the only person that supports me, my son, my nephew, my girlfriend, and my girlfriend's sister.
So y'all are all living together in that apartment?
Yes, ma'am.
But you're the only worker there?
Yes, ma'am. They stay home and take care of the kids and DoorDash as needed.
And how many children do you have personally?
One.
How old?
4 months. Just turned.
4-month-old, and his mother?
His mother is 18, fixing to turn 19, November 15th.
Well, you're not very old. How old are you?
I'm 19 now.
Okay. So, Mr. Lankite, I'm going to find that you're not indigent, but you didn't make a good faith effort. Even if you were indigent, you could have solved this problem without any undue hardship. We set those for hearing. We sent to the letters to the place that you were supposed to. You just didn't follow through. We even receive on a late payment. If you'll email me, you didn't even do that. You also missed your next court date on a no insurance that you got on January 1st of 2024. That fine range is $175 to $350. Court costs on that are $131. Regarding that charge, do you want to plead not guilty? It was that ticket on 10th in Houston in a Grand Marquis. Do you want to plead not guilty because you want to bring me your insurance, or that you want to hire an attorney or have a trial on that stop?
I would like to plead not guilty so I can bring you my insurance, ma'am.
Okay, so on that one, when you get out of jail, whenever that's going to be, because you're still sitting out $335 unless somebody pays it. So
yes, ma'am.
The perspective, that means it's 2 more days plus starting tomorrow. So tomorrow's Friday, Saturday, you'd probably get out sometime Sunday unless somebody pays it. Then when you get out, you'll bond out on this with a PR bond, because I want you to spend all your money on paying your old tickets.
Yes, ma'am.
So get a PR bond. When you come see me, bring me that insurance that you're supposed to bring last time.
Yes, ma'am.
Okay, any questions?
No, ma'am.
So if you're making a call, as of right now, you owe $335.
$335, yes, ma'am.
Okay, and then when you get out, come see me on the date and time of your bond.
Yes, ma'am.
Okay, see you soon.
Yes, ma'am. Thank you.
Bye-bye. Jesse Espinosa.
Yes, ma'am.
He was almost reasonable.
Just 1 second. I just want to be sure I gave Mr. Lankop the right amount of jail credit. None. Okay. All right, Mr. Espinosa. This charge is called assault by contact family member. The fine range is $100 to $500. The court costs are $81. It's one of the charges that, as a Class C misdemeanor, is really one of the most serious charges we deal with in my court, because it has a lot of extra consequences if it becomes a conviction. So to make you understand what a conviction means, you get a conviction if you plead guilty or no contest and you don't have a trial, or you get a conviction if you have a trial and you're found guilty. Then, if there's a conviction in the future, federal law says you cannot own firearms or ammunition, and if you do, you'll be seeing a federal judge, not me. So it's a federal crime to own or possess firearms or ammunition if you have a conviction for an assault family violence. Future charges of assault can be filed as higher level charges with proof of a prior conviction for this assault. It can affect rights to child custody. So do you have any questions about what your rights are? You have the right to plead not guilty. You have the right to hire an attorney. You have a right to have a trial. This assault is regarding Adriana Espinosa by hitting her. Do you want to plead not guilty and come see me pursuant to a bond?
Yes, can I plead no contest?
If you plead no contest, all those consequences attached to you, because I do find you guilty, and I enter a judgment convicting you of assault by contact family member.
So, do I plead not guilty for the PR bond?
Well, I'm not necessarily going to give you a PR bond. I'm going to look at your history of appearing in my court. Let me look at what that is. I'll consider a bond, and I'll consider the type of bond based on your history with the court. So I'm just going to look. We have a long history, but it's been a while since I've seen you.
But I'm on bond right now for some other stuff, so I'll be able to abide by it.
So are you on, what are you on bond for? Because it's not in my court.
It's for like evading arrest or something like that.
Okay. But not to it didn't happen on September 4th.
No.
So when I look at your history, I do see a history of troublesome not appearing. So if you plead not guilty, that's perfectly fine. It'll be a cash or surety bond. You'd have to call a bail bondsman. And there would be conditions on that bond. And the condition would be that you have to stay a football field away, so 100 yards away from Adriana Espinosa, and you make no contact with her.
For how long?
What?
For how long?
Well, until the charges
That wasn't me, by the
one
way.
way or the other.
Okay. Well, okay. Now, I didn't understand the difference between what you said about pleading no contest and not guilty. The consequences.
Okay, not guilty means that you want to bond out to perhaps have a trial in the future.
Okay.
You have $500 cash or surety bond. Most likely you call your bail bondsman, bond out on it, and then the conditions of the bond are basically no contact with Adriana Espinosa and stay 100 yards away from her.
Okay.
The no contest plea means that you just want to talk to me about how to pay it, but all those consequences attached to you regarding getting a conviction for assault by contact family member, meaning can't own or possess firearms or ammunition. The conviction can be used against you if you have a custody issue with regard to any children. This conviction in the future can be used as an enhancement for any future assaults. So your future assaults could be filed as higher charges with proof of a prior conviction.
And what would the same thing be as not guilty?
Not guilty means you're going to come see me on the date and time of your bond and maybe set it for trial.
And guilty, I mean, what's different about guilty?
Guilty has the same consequences as a no contest plea. I find you guilty. If you plead guilty or no contest, I find you guilty. All those consequences attached to you, and you're going to have to come see me.
This is like the guy that makes the waitress say every salad dressing. You know, it's like let's go through the entire universe of possibilities.
No matter what you do, to talk about the balance that you owe, because you've only been there one day.
So if I plead guilty, I get a PR bond? No PR bond.
If you plead guilty, you don't bond out. You come see me about how to pay the balance. If you plead not guilty, you get a cash or surety bond with conditions on it.
I don't understand. So if I plead guilty, I'm just gonna stay here?
No, if you plead guilty, you'll probably be processed out today. If you plead not guilty, since you have a bail bond company that you're acquainted with, you'll probably get bonded out today.
Let me just plead guilty.
Okay, on your guilty plea to assault by contact family
Let's go with
member,
guilty.
final court cost is $485 with $150 jail credit. You still have to come and
I'll
see
take
me
range.
tomorrow to talk about how to pay the balance, which is $335. Now, I did give you the family violence warnings, and tell me who is Adriana Espinosa?
She's my daughter.
Okay, so I'm making the affirmative finding of family violence You've got to come see me tomorrow at my courthouse. Be here at 1:45 to see me at 2 to talk about that balance. When you appear, and also before you leave, we're going to give you those written family violence warnings. Do you have any questions?
No, ma'am.
Okay, I'll see you tomorrow at 1:45.
Well, I'll be getting out right now in a minute, or
You'll
what?
be processed out today, and I would highly recommend that you still don't have contact with Adriana Espinoza.
Yes, ma'am.
Colton Lehman.
Yes, ma'am.
Did I say your last name right?
Yes, ma'am.
Okay, this charge is called drug paraphernalia possession regarding a baggie from September 5th. Do you want to plead, the fine range is $100 to $500. Do you choose to plead not guilty because you want to hire an attorney or have a trial?
I'll plead guilty, just get this over with.
Well, you get it over with not guilty because no matter what, you've got to come see me either on the date and time of a bond or tomorrow at 2.
So if I'll just plead guilty.
Okay?
No, I'm guilty.
Huh?
I'm guilty.
Okay, on your guilty plea, finding court cost is $531. I'm going to give you $150 jail credit. So $531 less $150 is $381. You've got to come see me tomorrow. Be here at 1:45 to see me at 2 to talk about that balance of $381. The only way you don't have to see me is if you just pay it.
Okay. But I'm still getting processed out today no matter what?
Yeah, you're getting processed out today. You can see me tomorrow be here at 10:45 to see me at 11, or be here at 1:45 to see me at 2. If you fail to appear for that 2 o'clock docket or before, then I issue capious warrant. That's how you end up sitting it out.
Yes, ma'am.
Any questions?
No, ma'am.
Okay, thank you. You can return to your pod.
Thank you.
Mr. Weedling?
I like this judge,
Is it Weedling?
but she's not quite as fun as Judge Mom.
Weidling, I'm sorry.
It's the same call.
First one to ever do.
I'm sure I'm not, but I do like to say people's names correctly. This charge is from September 5th. It's called public intoxication. Fine range is $100 to $500. Do you feel comfortable making decisions for yourself this morning?
Yes. I'm going through an actual ILP treatment as we speak, and I just had a hiccup.
Okay. So you feel like your mind is straight, you're able to make decisions for yourself?
Well, I think tonight or this morning obviously shows that it's not accurate.
So you can't make a decision for yourself right now?
I can right now, yes.
Okay.
Ma'am.
So to the charge of public intoxication, do you want to plead not guilty because you want to hire an attorney or have a trial?
What does it cost?
The fine range is $100 to $500. Either way, you're getting out today. So
Okay.
you're either getting out today. Well, you've got that criminal trespass. Have you seen a judge on that?
I have not.
So you're going to see a different judge regarding that and probably get a bond set for that. So I can't really say that you're getting out today, but I would not still be holding you there either way. So if you plead not guilty, I'm going to give you a PR bond, which is your agreement to appear on the date and time as you're bonding out. It tells you when to appear. Or if you plead guilty or no contest, when you get out, you have to come see me on the next business day. So if you get out today, you got to see me Friday. If you get out on Friday, you got to see me Monday. Friday, Saturday, Sunday, you've got to see me Monday. Because you don't continue to get jail credit as you're there because I'm not holding you there.
I won't get jail credit.
You don't get jail credit after you've entered a plea, and I've given you the jail credit you're due so far. So really, almost the safest thing to do, since we're not sure when you're going to get out, is to plead not guilty. And so as you're leaving, you'll get a bond, and it'll tell you when to see me.
And when is going to be the next trial, or not trial, but the next
judge that you'll see? Probably sometime this morning. The officers in the back will tell you.
Oh, okay. I got you.
Okay, so do you want to enter a not guilty plea so you're sure that you're not going to miss coming to see me?
Yes, not guilty.
Okay, so I'm going to set a PR bond. All the PR bond, it's a contract you make with the city. So as you're leaving, don't forget, you got to come see me on the date and time of that bond. If you miss it, then I issue a warrant and forfeit the bond. You owe the city an additional $500.
I know the date and time I'll be there.
You will. You'll sign that bond. Okay, thank you. You can return to your bond. You can ask them in the back when you'll see the next judge.
Thank you.
there you have it. It turned into a long stream, but I had lots of good material. What are you gonna do? I just had lots of good material. I wanted to do it all. So there you have it. Good times. Amarillo Court. It's still good, even without Judge Mom. And all the rest of it. The SovCit was fantastic. I can't remember Fernandez, the guy who took off with on foot from his car and left a bottle of tequila in there. There's nothing, you know, you can't get much more busted than that. When you're running from your car, but you left a bottle of tequila in there, the police are going to piece that one together. Every time. They're gonna follow those breadcrumbs and make some conclusions. That's just the way it is. All right. Thank y'all for coming out. I appreciate it. I will see y'all soon.